Hey Andrew, can you tell me some more about the legality of recording other people's conversations and videos?
Okay, well, it's actually kind of a tricky area, and it's not consistent between all places, meaning all states. There's a difference between the federal law and what the law is in Florida. And basically, the law in Florida regarding recording a conversation with someone uh, differs from many other states because Florida is what's called a two-way consent state, meaning that both parties have to be aware and consent to the recording that's going to be made. Now, everybody's got a smartphone in their pocket or their purse or their briefcase, and smartphones seem to always have a function in it where you can just put it on the table and hit that little record button and think that you're being really clever because you're recording the conversation of the person that you're talking to. Now, it could be a salesperson at a car dealership and you want to make sure that you've got what they're saying down, or in our own practice, since we do so much medical malpractice, clients come in and say, "Oh, I recorded that doctor and he admitted that he made a mistake." Well, when you hit that record button and you don't have the permission of the person who you're recording, you're not creating a legally admissible document or a legally admissible recording in the state of Florida. And you're also committing a crime. So let's talk a little bit about what's required in Florida when you want to record somebody. In Florida, the law regarding recording a conversation requires the consent of all parties involved. And anybody who is really motivated can take a look at Florida statute section 934.03, which is available online. And it states that it's unlawful to intercept any wire, oral, or electronic communication unless all parties to the communication have given prior consent. Now, this has been the law in Florida for quite a way. Let's see, going back over 45 years, maybe 50 years. And this means that in Florida, secretly recording a conversation by one of the participants without the consent of the others is prohibited. And this differs from federal law and the laws of many other states, which often allow one-party consent. Under the federal law, which is covered by 18 USC section 2511 to C and D, it's not unlawful for a person to intercept a communication, meaning record a communication, if that person is a party to the communication, meaning if you're part of that communication under federal law, you can record it, or if one of the parties has given prior consent. States such as Georgia and New York also follow the one-party consent rule, where a recording is permissible if one party consents. If for example, in Washington, D.C., or actually, I'm sorry, Washington State, the state constitution and Privacy Act provides that recording a conversation with the consent of one party does not violate the state constitution or the Fourth Amendment to the United States Constitution, which deals with search and seizure, which is actually all encompassed in the concept of obtaining evidence illegally or improperly. Now, Florida's requirement for all party consent is stricter when you compare it to the one party consent laws in many other states and federal law. And when people come to us and they say, "Oh, we recorded that," we have to warn them that what they've done is to actually, they've violated the law. Um, in Florida, if you've improperly recorded someone, depending on the circumstances, it could be as much as a third-degree felony. Now, what's a third-degree felony? A third-degree felony can result in as many as 5 years in prison. Not a pleasant outcome for just secretly hitting that button on your smartphone. Under other circumstances, it may only be a first-degree misdemeanor or a second-degree misdemeanor. In the case of being a first-degree misdemeanor, it could be as much as a year in prison, or, or more likely a year in the county jail, or $1,000 fine. If it's a second degree misdemeanor, it's 60 days. And it just depends on the circumstances. Now, that doesn't mean that a state attorney is going to be all upset with prosecuting a case regarding a secret recording. It's probably not going to be one of their highest priorities. You can probably negotiate a lesser sentence or plead down to the second degree felony, but a second degree misdemeanor rather. But it's not something that you want to do. So you have to be aware of the fact that in Florida, you cannot secretly record someone. Uh, this is important because people, have really become addicted to that function on their smartphones. It's very convenient to record a conversation. It means you don't have to take notes. Well, you don't have to take notes, but you just have to tell somebody that you'd like their permission to record their conversation. So that's these are some hints about recording in Florida, and that's where I practice law. And if you're going to be taking the recorded statement from someone in Florida, just make sure that they are aware of the fact that you're recording them. And don't just slip your phone into your pocket and hit that button and think that you're being real cute because you've got somebody on the record making a statement. You, in fact, are violating the law in Florida, and there are criminal sanctions if the state attorney were to choose to impose them. So that's our tidbit for today on audio recording and staying out of trouble. And I can tell you that recordings, both video and audio, can be very, very helpful in a civil lawsuit. They just have to be admissible and proper. So you have to have the permission of the person who you're taking the statement from. That's a wrap for today. And I hope this has been helpful.